Hello everybody and welcome to this session where I'm going to look at some revision and exam guidance with you, and also I'm going to go through the mock with you. So what I'm going to do today is a couple of things. I've done this as a recording rather than in a live session. I'm going to start off with some slides, as you can see here, and then we're going to move on to some feedback on the mock exam after that. So I'm going to talk through some slides first, and then we'll look at the mock a little bit later. So in terms of the exam then, some things to note. There will be advanced facts 7 days before the exam itself. So you'll get those in advance as you have for your other papers, for example, BLP, and as you will for your other electives, of course. You need to make sure you review the advanced facts thoroughly as part of your revision. One of the things that we tend to notice with students is sometimes, they don't use the advanced facts in answering the questions, and it is important for you to do that. So it's important that you're familiar with the advanced facts so that you can use them in the exam itself when you're answering the questions. It's an open book exam, obviously, so you need to make sure, I know you're doing it online if you're sitting the next sit, so you need to make sure you've got access to all relevant books and papers during the exam itself so that you can find things as you need them. There are student notes for all of the SGS's, detailed ones apart from this one. I've got the slides here for this one, but not a detailed student note. You need to make sure you have all the handouts and student notes obviously available to you during the exam. So make sure also that you're familiar with those. So you're not trying to find things in the exam. You should have studied those and looked at those as you've been going through the course. And you need to make sure they're to hand when you're doing the exam itself. The exam itself will cover a broad range of the subjects. Okay, so it's not going to be just on one topic. It will cover a range of topics, and any part of the commercial course could be tested. So it could be on questions on, there will be questions on a range of topics, and as I say, any part of what we've covered in the different 9 units could be tested. There are special arrangements, as you're aware, in place because we're doing this as an online assessment rather than a live SAT exam at the university. You need to make sure that you have fully familiarised yourself with the rules, etc., regarding the online assessment. I suggest you consult Blackboard and also your emails for all relevant information. In terms of this exam, there is no set reading time, so the time you have, you can spend as you wish, but I would advise that you read through the question paper before you start so that you familiarise yourself with the paper. There will be, in terms of what the questions are about, there are, as I've said, the advanced materials. Within the advanced, there could be one or more fact patterns in that advance. So to give you an example, it could just be about one client. You could have one client, Roger, that you're advising, or you could have another client, Smiths Limited, that you're asked that there's different facts about. So you could have, a couple of different fact patterns, or you could have, it could just all relate to a single client. So just to be aware, not to be thrown by that if there's more than one client. So there'll be fact patterns in the advance with information, telling you about what's gone on or giving you some background. There may well be additional information in the exam itself. If they're large documents, they will be in the advance, but you might get a short bit of additional information, a short document, or some short additional information in the exam itself. And just to remind you that the exam's in 2 parts. Part 1, which is the worth 85 marks. Those marks relate to sort of questions where you're advising the client. You've then got, after the part 1, you've got your part 2, which is the multiple choice. And there are 5 multiple choice questions that are worth 3 marks each. In terms of preparation then, I think it's important not just to focus on the lectures when you're revising. You need to make sure that in addition, you've done all the background reading, so you're familiar with the information in the book, in the textbook, and the textbook that you've got, the CLP manual, has a lot of very helpful information, so you should use that. And you've also, of course, got the lectures, but not just those you need to focus on. That's important as well, that you go back over the SGSs too, because in the exam you're being asked to advise a client. So that's like we've done in the exercises in class, where we're looking at advising a client how they should proceed in a particular matter. So if you just focus on the lectures, you're not going to pick up perhaps all of the sort of practical points in terms of application. So it's important that you've done all of your work sort of throughout the course, but also in terms of revision, going over the textbook, the lectures, and, as I say, the SGS exercises too. And as I've said, there are student notes for those. You need to organise your information so you can access things quickly. I think that's going to be part of the issue for you in the exam, is being able to make sure you can find things quickly. So make sure that you know where everything is and that you've got things organised. In terms of what we've covered a lot of ground. So just as a quick reminder, units 1 and 2 is sale of goods. Right, so we've covered that area right back at the start. So that was the first thing that we did. We then moved on to look at international sales in Unit 3. Then we've looked at agency in Unit 4. We also looked there, if you remember, at an agency agreement and also the agency regulations. And then in Unit 5, we moved on from there to look at a distribution agreement. So we talked about distribution and also competition law in that part. And Units 1 to 5 are what we call the commercial part of the course. We then moved on to the second half of the course, which is the intellectual property half. And we started in Unit 6 with trademarks, moved on from there to copyright. Then we looked at design rights and patents in Unit 8. And finally, we looked at confidence, which was last week in Unit 9. So you can see that we've covered quite a lot of ground. As I said, that there is good coverage in the textbook, in the lectures, and also in the SGS student notes for those different topics. So you need to make sure that you have revised across the topics. Moving on then to the exam and in terms of technique, a couple of pointers really. You need to make sure that you answer the question and apply the facts, because it's not a theoretical exercise. It's not like doing an exam maybe in an LLB exam where you might be discussing theoretically retention of title clauses, for example. In the exam, what you need to do is to advise a specific client on a specific clause perhaps and apply it to a given situation. And I'm going to work through the mock shortly, and you'll see what I mean about the approach to answering the question. It's not sort of abstract, it's very sort of practical. How do I apply the facts here? How do I apply the law to those facts to advise the client? Because that's key. To answer the question, you've got to advise the client. If there's not enough information, then you need to say so in your answer. There were some examples of that in class last week, for example, when we were talking about confidentiality agreements. You know, if you don't know, for example, whether there's a contract in place, or if you don't know whether someone's an employee or not, then you can say, obviously, in your answer, if more information is needed to fully advise. You need to make that clear in your answer. And again, I'll give you some examples of that in when we go through the mock shortly. You can answer the exam questions in any order you like. It doesn't make any difference. That's absolutely fine. So, you know, you may decide, for example, that you want to do a particular question as a particular area you're confident on. You'd like to do that first. You might decide to do the MCQs first because you decided that, you know, like to get those out of the way. It doesn't matter. You can do the questions in any order you wish. Do be careful about running out of time. You shouldn't spend too long on early questions. And also you need to kind of think about how many marks there are for a question. So if a question is not worth many marks, obviously don't spend too long on it. So you do need to be careful about that. This is a pitfall that students sometimes fall into, that they spend too long on a question for very few marks and then run out of time for a longer question later on. So be aware how many marks are there for this question, and secondly, making sure that you're not running out of time. You might want to set yourself, sort of a timer or whatever to keep an eye on how much time you're spending in the different questions. Okay, so and as I've also said before, the MCQs are worth 15 marks. That's quite a lot. So you need to remember to allow yourself time to answer those. If you in terms of when allocating your time, don't just leave those till the last minute and then run out of time, because that would be 15 marks. So you do want to make sure you've got a bit of time to answer those questions. So those are the main things then that I wanted to say in terms of looking at the slides there. And as I say, really just focusing on the exam, coverage, etc., and technique. What I'm going to do for most of this recording is I want to focus instead on the mock itself and talking you through that. So I'm going to open that document now. Okay, this is the document that you have on Blackboard. So I've just got it here. So what I'm going to do first of all is I'm going to talk you through the document, and then what we're going to do is I'm going to take you through how to approach it or what's relevant to the different questions. So a few things to notice here. First thing to say is that the front sheet to this document, both the advance and the question paper here, these are the standard front sheets, the standard instructions. Obviously, these will be changed. There will be different front sheets on these special cover sheets to reflect the special arrangements for the online examination that you will be doing. So this obviously reflects the situation as it is in terms of, it's a standard front sheet, but there will be an updated front sheet to reflect the current situation in terms of the exam being taken online. You need to check the dates, obviously, in terms of what date the exam is and when the advance is being issued. Make sure you check for that. One thing just to point out is that this is all of the marks for the commercial law elective, so there isn't anything else. And so, just to kind of flag that up, really. I'm sure you were aware of that already, but just as a reminder. All right, so moving on then. The next thing I wanted to draw to your attention is on page 3, where you'll see it talks about the advanced materials being distributed in advance. And it says that the questions will be based largely, but not exclusively, on the facts and characters contained in the documents listed below and which are attached. You must therefore bring them with you to the exam. You'll be given the questions in the exam. So I kind of alluded to this earlier when I was talking about the slides. The questions will be based largely, but not exclusively, on these facts. So there may be additional information and there may be additional facts and information in the exam itself. But you need, of course, to have the advance to hand during the exam. And as I say, to have made sure you've gone over them carefully in advance. People often do not. And of course, you need to be able to refer to the detail that's in the advance when you're answering the question. So that is important. Moving forward then, so the first document we've got basically is some background information about the client. So the client's electrical elegance, and we're told about their product, what they supply, digital car radios, MP3 players, etc., TVs. It tells us a bit about their business, their plans to export to the continent, talks about developing a new aerial system. And it makes clear that the director has been to ask for some help. And then we're told that they sell their goods on the basis of the attached standard terms and conditions. So the document then, next document you've got, is a set of standard conditions of sale. So I've turned on to that document now. So this is document 2. So on this occasion, just to point out that the document that you've been referred to is a set of standard terms and conditions. It may not always be, however. It could be a set of terms and conditions in the advance. It could be another form of document of the kind that we've looked at before. So, for example, we've looked at agency agreements. It could be an agency agreement. We've looked at distribution agreements on the course, so it could be a distribution agreement. If it's a long document, you will be given it in advance. As I've said, you might be given an additional shorter document or extract in the exam itself. All right, so if it's a long document, it will be in advance. I'm not going to spend a long time going through this document now with you, but what you should do yourself once you get the advance is to go through it carefully and note any sort of key provisions that you think might be significant for the purposes of the exam. So you'll need to go over it quite carefully. All right, so we'll leave that advance to one side for now. As I say, we'd go through that, or you would go through that when you're doing your preparation for the exam, and then we move on. So that's the end of the advance. Here is the question paper. And as I've said, bear in mind that there'll be a special front sheet for online exams. So let's start looking a bit further down then. So again, remembering it's marked out of 100%, and then we're going to look at the actual question paper itself. So the first thing to notice here is that you've been given some extra information around the information on which the client seeks advice. You've got some problems in relation to some batches of sound systems that EEL has sold. The first dealer, Bond, has raised some problems. The second batch was delivered to Moneypenny. Both sales were made on the standard terms, you'll see, which is set out in document 2. That's the document in the advanced materials. And then in 2 here, you'll see that there's information here around complaints about malfunctioning radios, but then it talks about the fact that there's a small company has been selling imported radios, and they're anxious to stop this unwelcome competitor. And then moving on, point 3 talks about the fact they want to protect a new aerial system. And one of the employees is threatening to join a competitor. And then we've got EEL has decided it wants to sell some of its products in Europe, and it is proposing to appoint a distributor in France, and you've got some proposed terms attached. And those are later on in the paper. You'll see they're actually very brief. As mentioned before, it's not a big document. The main long document was in the advance. The document here, document 4, is quite a short document, just with the terms of the proposed distribution agreement. All right, so having looked at that, let's move on to the question paper, the actual questions. Part 1, you must answer all of the following questions. There's no choice, all right? If you leave something out, you're just going to lose marks. You have to answer all of the questions. On this question paper, you'll see there are 4 questions, each one relating to a problem described above. You may, in your exam, have more than 4 questions, but that doesn't make any difference because it will still add up to 85 marks, okay? So there will be questions worth 85 marks for you to answer. Whether there are 4 or more is not really that particularly relevant, but the key thing is you need to answer all the questions if you can, because it's there's no choice. All right, so let's start then with question 1. So question 1 says to consider the complaints raised by Bond Limited along with the clauses set out, and to answer the following questions. Okay, so consider to what extent EEL's liability for the lack of quality alleged, to what extent would it be protected by clause 9 of the standard terms in document 2. So we may want to refer back to clause 9 in a minute to look at that when we're answering this question, but first of all, just to kind of clarify, as I said, I'm going to give feedback in relation to each of these questions. In doing that, I'm going to give more detail than you would need to answer the question yourself in the exam. That's to give you a fuller answer to assist you for revision purposes, but I'll also indicate what sort of approach you need to take in the exam. So I'm going to give a fuller answer, but also because that will assist with revision, but also I'll indicate what sort of answer is appropriate for the exam itself. So looking at this first question about bond then, there's two aspects to this question really. First of all, there's the question of to what extent, consider the extent of their liability for lack of quality. And then the second element of that question is, the second element of this question is that to what extent would it be protected by clause 9 of the standard terms in document 2? Right, so there's two different parts to that. There's the extent of the liability, and then secondly, there's the extent to which they'll be protected by clause 9. Okay, so let's look at the extent of the liability question first of all. So the first part of that question. Basically, in a business-to-business contract like this for the sale of goods, the goods are expected to be of satisfactory quality in accordance with section 14.2 of the Sale of Goods Act. And if the goods don't meet that standard, then that would be a breach of condition. And that would, generally speaking, entitle the buyer to reject the goods and claim damages. Okay, so if they're not of satisfactory quality, that would be breach of condition. It would entitle the buyer to reject the goods and claim damages. On the facts here, one thing that's questionable is the length of time that's gone on. The facts say that they were invoiced 6 weeks ago. Presumably the goods were supplied before that. So query whether it would actually be too late to reject the goods. But the basic point I would expect you to make here is to flag up section 14.2, that it would be breach of condition, and that the remedy for that would be damages, the right to reject plus damages, and that those damages would be calculated on the basis of Hadley and Baxendale principles. So that's the first part of the question. The second part of the question is asking about the extent to which they'd be protected by clause 9 in the standard terms. And what clause 9 is doing basically is seeking to vary the implied position that we've just described in terms of what they would normally be liable for in terms of quality if they have not varied the position. So we therefore need now to determine what clause 9 says and the extent to which it will be effective. So let's then move to look at clause 9. So I'm going to move away from the question now and back up to clause 9. And this is where obviously you'd have needed to look at clause 9 in advance, because to answer this question now what you need to do is you've got to think about, as I've said, the extent to which it's protected by clause 9 and the variation here. There are 3 tests essentially of the effectiveness of exclusion clauses. You need to consider whether the clause is incorporated, how it's constructed, and then to apply UCTA. And that approach to exclusion clauses is mentioned in your textbook. So it's a kind of standard method for working out how effective a clause is. And so here, there is nothing really to suggest on the facts there's any issue around incorporation. We've been told simply that all contracts are entered into on these terms and that these terms applied. Therefore, there's no issue with the first aspect. So therefore, we need to move on to look at the construction of clause 9 and its application here, and then to consider how UCTA may apply. What I'd suggest you do is actually to look at the clauses one by one and then to apply UCTA afterwards, because otherwise you might find that you're being very repetitive. So it might be easier to do it that way. So looking at the different parts of 9 here, you'll see that 9.1, what that's doing is it's saying that the goods that are supplied, firstly, they'll correspond with their specification and that they'll be free from defects for a certain time period. Well, more information is needed here because we don't know what the specification said, and we also don't know what the time period is because it's not completed. So we don't actually know if that time limit has expired. So that would be something where we might need more information. So that's 9.1. Then let's move on then to talk about 9.2. So 9.2, it goes on to say that claims based on defects must be notified within 7 days from the date of delivery in writing. So I guess there's a question here, was that complied with? But note here, if the defect or failure is not apparent on reasonable inspection, then within a reasonable time for discovery of the defect. So I guess there's a number of questions here. Was the defect apparent on reasonable inspection when they first got the goods, in which case they needed to notify in writing within 7 days? And did they do so? If not, if it was not readily apparent, have they notified within a reasonable time after discovery of the defect? Those are questions on the facts that we need more information about, but I would expect you to draw that out here in the way that I've just described. In the absence of notification, then they're excluding liability and requiring the buyer still to pay the price. Right, so that's 9.2 at the moment. I'm going to come back to UCTA issues later, but that's really talking here about what the clause is providing and applying it to the facts here. So we need to know, was there a defect that was apparent on reasonable inspection? If so, did they notify within the 7 days? If it wasn't something that should have been apparent on reasonable inspection, did they notify within a reasonable time of discovering the defect? That's the kind of key things we need to know there. Then we've got clause 9.3 here. Note the rubric above, and we're going to come back to that in a little bit later when we talk about UCTA, where any valid claim in respect of any of the goods is based on a defect. If it's notified, then it's setting out here what the remedies are. The seller shall be entitled to replace the goods or the part in question free of charge, or at the seller's sole discretion, refund to the buyer the price of the goods or the proportionate part of the price, but shall have no further liability. So basically they're capping, here the seller's capping their liability at the price as a maximum and making it clear that the seller has the choice either to replace the goods or the part in question, or if they wish at their discretion to refund. But above that, and it's capped at the price. No further liability. So then here, 9.4, the seller shall not be liable for any consequential or indirect losses. So they're excluding any indirect or consequential losses. And they've listed here non-exhaustive illustrations of consequential or indirect loss would be loss of profits, loss of contracts, etc. Just to point out there, just to make sure you're aware, loss of profits is not necessarily indirect loss. It's not necessarily the case that loss of profits is indirect loss. Loss of profit quite often can be direct loss. If you think about it logically, if I sell you some goods for resale and there's something wrong with them, the most obvious loss to you, I'm supplying the goods to you, you're a retailer, the most obvious loss you're going to have will be the loss of profit of selling the goods on. Yeah. So that would not be indirect loss, that would be direct loss. Right? So just referring to loss of profit here is indirect does not mean you can exclude all loss of profit. And again, that's something I'd expect you to pick up, and that's something that's covered in the textbook as well, that you could have picked up from the textbook when it talks about indirect losses in relation to when the loss can be indirect or consequential, that loss of profit can fall under the first limb of Hadley and Baxendale, which means that it's direct loss. So that's something to be aware of. All right, so just to make the point then, in 9.4, they've excluded indirect consequential losses, but loss of profit is not necessarily indirect, and therefore would not necessarily exclude on its construction direct profits, which would fall, of course, to be considered then under 9.1, 9.2 and 9.3 in the usual way. So that would be something to bear in mind there. So once you've gone through the clauses, 9, just to point out 9.5 is force majeure and not relevant really on the facts here. There's nothing to suggest that it is. So that's all you'd need to say about that. Then you'd need to talk about UCTA. So you'd be needing to say that, that in relation to the clause 9 here, it needs to satisfy the requirements of UCTA, and any exclusion, because it's standard terms and conditions, needs to satisfy section 3 of UCTA, so all exclusions need to satisfy section 3, and the specific exclusion in terms of like varying section 14 here needs to satisfy the requirements of section 6 of UCTA. So sections 3 and 6 of UCTA, and both of those require that any such exclusion has to be reasonable. So you would need to be considering the reasonableness test here in relation to section 3 and 6, and you'll be saying here that the reasonableness test is set out in section 11 of the beg your pardon, it's set out in section 11 of UCTA, and also it's also set out in Schedule 2 as well. So it's section 11 and Schedule 2 that you need to refer to there, okay? And that's important to make sure that you do that. Now, you could, as I've said, apply UCTA to the separate subclauses as you go through, but I think that would take longer. I think it makes more sense to refer to it at the end and just to deal with UCTA once. And so here, there's a question mark around how reasonable it would be. The time limit's quite short. And I guess it's partly going to depend what's wrong with the goods, which we don't know on the facts. So you need more information there to advise on that, really. You would need to talk a bit about the fact that obviously the court takes into account all the circumstances of the case. So it would depend as well on factors such as the factors in section 11 and schedule 2, which include whether the risk can be insured against, etc. In terms of answering this question, those are the main points in terms of dealing with that. As I said, I've gone into a lot more detail, but you would be expected to look at the different subclauses and apply them to the facts, as I have done. And also to talk about UCTA and here, to draw in the facts as much as you can, as I've done, as I've gone through the answer there. In terms of the approach to exclusion clauses that I mentioned, that you need to think about the stages for effectiveness, that's dealt with on page 96 of your textbook, if you want to have a look at that later on. All right, so I find the difference in those sorts of questions is that quite often students, just to tell you about sort of good and bad answers to that type of question, the bad answer is that the student barely refers to the clauses, just a single sentence referring to UCTA and no attempt to sort of apply or talk about the facts, not spotting issues such as the fact that in the question, for example, it talks specifically about profits, that therefore this issue around clause 9.4 is important. I've just realised when talking about 9.3, what I didn't mention was the rubric. I mentioned that the first time round. When you're looking at the reasonableness of clause 9.3, one of the factors would be the rubric. That's RUBRIC, the wording immediately above, because the potential losses which the buyer may suffer, the seller limits its liability as follows. That bit, that's been put in to try and make 9.3 and 9.4 seem more reasonable. So just to make you aware of that. But I'd expect you, as I've said, to sort of pick up things like, have they exceeded the time limit? When did they notify in writing? Was it a fault that would have been obvious? Those types of things in your answer. All right, so that's that very first part of that question answered. Let's move on to question 1b. So flick forward again. So question 1b now. So see there also what's important at that first question is we answered both parts. We talked about the extent of their liability for lack of quality and then the extent of the protection in clause 9. And notice there's 14 marks there, so you would expect quite a bit of detail for 14 marks. In terms of question 1b there, steps to be taken by EEL to protect its position in relation to Moneypenny. Preliminary check has revealed some of the systems sold, others have been fitted to cars as yet unsold, the majority still in the packing in which they were delivered. This is clearly another question around the terms, but this time it's about late payment. So it's looking at a different aspect here. Looking back at the facts here, just briefly again, this is what you need to do. So in the previous question, you'd have wanted to look at this. So here, in relation to bond, they were talking about the fact that we invoiced 6 weeks ago, etc. I drew that in my answer to 1A. In 1B, it talks about the fact that goods were delivered at about the same time, no complaints about quality, payment not received on time, and they've heard a rumour, money pennies in financial difficulty. Again, sale made on the standard terms in document 2. So this is about late payment. What that brings us to then is issues with payment. So let's see what the terms and conditions say about that. Right, so clause 6 says that they have to pay within 30 days of the invoice, and the facts seem to suggest it's around 6 weeks ago, so it's clearly longer than 30 days. Then 6.3 says that if it's overdue, the seller can charge interest at 10% per annum on overdue amounts. So that's something to mention as clause 6.3. So interest may be due. And then it takes you to 6.5. It says that if the buyer fails to pay the price on date specified, seller can terminate the contract and recover the goods in accordance with clause 8. Okay, so that's clause 8 is the retention of title clause. So clause 6 is clearly relevant, clause 8, but just to draw something else to your attention, the information tells us that they're aware of, they've heard rumours that the company is in financial difficulty. So you should also think about clause 10, which is about insolvency. So if the buyer, being a company, has a petition presented for winding up, passes a resolution, etc., the seller reasonably apprehends any of those events as about to happen and notifies them in writing, then they can treat the contract at an end. And if the goods have been delivered but not paid for, the price shall become due immediately, regardless of any previous agreement to the contrary. So clause 10 then would also trigger the rules around late payment potentially. Okay, so clause 6 itself, if it's over the 30 days, yes, but also worth mentioning here because you're told on the fact that the company, they've heard rumours of financial difficulty. Also worth mentioning that clause 10 would also trigger the effect here that that once the price is due, then if they haven't paid on the date specified, then again they can recover the goods in accordance with clause 8. The main part of your answer here will be around clause 8. All right. So what you need to do first of all is to identify that clause 8 is an ROT clause, retention of title, and to point out that 8.4 provides that if it's overdue, then they can the seller has the right to enter, recover, and resell the goods, and to detach or remove the goods does not affect any other right of the seller. So that's something to be aware of there. So clause 8.4 is kind of your starting point. You need to mention that. Then what I suggest you do is to go back to the question, because the question, if you look at it, just flick back, outlines 3 different scenarios. It says that the first one, some of the systems have been sold. The second scenario, others have been fitted. The third scenario, the majority are still in the packing in which they were delivered. I would suggest that you deal with those one at a time to avoid missing any. All right, because the chances otherwise, if you don't do them in order, you might miss one. So I would deal first with the systems that have been sold. And your issue there, of course, is that once the goods are sold, your problem is going to be around the fact that the sub-buyer will have taken title. And that's specified, if you look here, that in clause 8, right at the start, 8.1, ownership of the goods remains with the seller and will not pass to the buyer until one of the following events occurs. The seller's paid for all of the goods and no other amounts are owed, Or alternatively, 812, the buyer sells the goods in accordance with these conditions, in which case ownership of the goods passes to the buyer immediately before the goods are delivered to the buyer's customer. And that's what's happened here, isn't it? They've sold the goods on. So 812 applies, and that's the buyer would take good title. However, there's another relevant clause here to look at, 8.5, which deals with that situation. Until the buyer's paid the seller, then in that situation, the buyer shall hold the proceeds of sale on trust and separate bank account, and the seller may trace the proceeds of sale into any bank account which the buyer maintains. So there's an obligation on the buyer to keep that money separate, and saying that the seller can trace the funds into that account. Now, I'm sure you'll recall that this is one of the big problem areas for retention of title clauses, and those types of clauses are very difficult to enforce. So that's going to be a real difficulty here. I guess the first question is whether they put the money in a separate account at all. So did the buyer actually comply with that? But in any event, the right to trace is likely to be ineffective. You'll recall from looking at this in Unit 1 that that would create a charge that's registrable under the Companies Act and would be void for non-registration against creditors or insolvency practitioners in an insolvency situation. Section 859H needs to be registered. It would be otherwise, as we've said, if it's not registered, it's void against interested parties of the type listed in the section. So if you have a look in section 859H, section 8. Let me just look that up. Hold on, folks. I've got my handbook in front of me. Make sure I give you the right reference. It's a while since we looked at company law. Yeah, it's section 859H. It was one of the additions. So it's section 859H, which says that the charge is void against a liquidator, an administrator, or a creditor of the company if it's not been registered. Okay, so it would be void against a liquidator, administrator, or creditor of the company, and the correct reference there is section 859H of the Companies Act. All right, so that would be problematic. It could, however, be enforceable between the parties still. So if they haven't got to that stage in terms of their financial difficulty, and it's still the company, it's valid between the parties, and could have bluff value if you can persuade them. But of course, a seasoned insolvency practitioner will know the law and know that that clause will not be effective. That's the first bit then. Then in relation to those that were fitted to cars, the question will be if they're detachable. You are allowed to detach goods. Look here under 8.4, it talks about the right of entry, but also the right to detach or remove the goods. So that would be something to think about there. You also need to check, of course, that the goods are identifiable. You know, is it clear that they are our goods? But provided they are, and if they are detachable, then that should be, on the facts, that seems likely. The leading case on that is Hendy Lennox, which again is mentioned in your in the note for Unit 1. All right, so that's the ones that are in cars but not yet still there. And then the final category that was mentioned was those that are still in the packaging. In that circumstances, the major issue will be, are they identifiable? Do we know which are our goods? There is an obligation under clause 8.3 on the buyer to store the goods separately. So the question will be, have they complied with that? If so, then of course it should be a simple matter of exercising the rights under clause 8.4 and repossessing the goods. So that should be straightforward, hopefully. So that's clause. That's the clauses applied there. And as I say, you know, the key one to talk about is clause 8. In order to answer that question well, you'd want to refer back to clause 6. A really good answer would have picked up the bit from the facts where they talked about financial difficulties and also referred to clause 10. In terms of sort of good and bad answers to this, again, it tends to be that students don't look at the clauses enough or talk about them enough in their answers, give a very superficial answer, just talk about ROT clauses, don't explain about, and forget maybe to deal with one of the 3 different scenarios, which is why I've suggested you deal with them one at a time. So those are the kind of key things to look out for in terms of answering that question. Let's move on then to the next question. So we've dealt with question 1. Let's move on then to question 2. Question 2 is asking about the activities of the rival company Axel. So we've dealt with these questions in relation to the terms and conditions. This is a completely different issue now. Rival company Axel, on the assumption no trademark's been registered, what action can be taken against Axel, and what evidence do we have to support each element of our claim? All right, now it's really important here that you have noticed the first part of that question. On the assumption no trademark has been registered. You will gain 0 marks for writing about registered trademarks in answer to that question because you've been told there isn't one. So you could write about it for an hour, you would still get 0 marks because it's not relevant to the question. All right, so do make sure you've read the question. So this question is asking you about passing off, clearly. It's asking about protection for an unregistered trademark, right? And the elements you need. So this is a straightforward question. Once you've identified, made sure that you've understood that it's asking you about passing off. All right, so, and looking back at the facts again here, it talks about this, doesn't it? It talks about here's the information. So you need to make sure you've read through this, maybe go back and read it again. They've received complaints from customers that car radios are malfunctioning. They've had information about them on an internet site investigation. It turns out small companies have been selling imported car radios under this name and the Serene and Serenity at Speed slogan, anxious to put a stop to this. So that's the what they're concerned about, and then just reminding you that in the advance, let's go right back, right at the beginning here, we are told that they sell under the brand name Serenity and they use the slogan Serenity on Wheels, and they've been going for about 6 years. So all of these factors then, and it talks about TV campaign, advertising campaign, etc. So let's go back to the question then. So we need to make sure that we've got the information there. So we've gone back through, we've checked the information from the advance, we've also got the extra information from the question paper. So looking at this question then, what evidence do we have to support each element of our claim? What you need then here is more than just to say what the 3 elements are for passing off. You should, of course, refer to the elements from the GIF case, Reckitt and Coleman and Borden, that key case. All the detail about the cases in the textbook is a short section on passing off, but it is very good. So in terms of passing off, you need the 3 elements, of course, the first of which is goodwill. Got to show goodwill or reputation attaching to the mark, including the slogan here, of course. And you could do this by showing things like the fact that they've been running this for 6 years, the fact you could refer to turnover, so you'd need details of that, the fact there's been an extensive marketing campaign. You would, of course, want details from the client around how much they spent on advertising, what sort of sales they've had, etc. But yeah, there should be elements there to show the goodwill. So you want to show goodwill or reputation attached to the mark, including the slogan. That's the first element. The second element then is that you need to show misrepresentation, causing confusion. And the confusion, as we discussed before, has to be as to trade origin. So there needs to be some confusion of the public as to trade origin. And of course, you could reference here to the complaints, couldn't you? It talks about the fact that people have complained, the fact that the slogan and name are so similar. That would be something to refer to, that people would be confused. They would, of course, be giving sort of evidence of that. It could include survey evidence, of course. and you'll be wanting to refer, as I've said, to all of those facts to suggest confusion on the part of the public. The fact the slogan and name are so similar, the fact that they've had complaints about it, all the evidence that you can show to prove confusion as to trade origin, that people think that this infringing product is theirs. And then the final element you need to show, of course, is the damage or likelihood of damage, and that would be to reputation, or could also be damage in terms of lost sales, couldn't it? So, it seems to suggest, because the rival product is faulty, that perhaps it is an inferior product, and therefore this could also have an impact on the reputation. The fact there have been complaints and people writing negative reviews on websites, if there's a fall in turnover, all of those may be relevant in terms of showing damage or likelihood of damage here. So those would be the elements you'd need to talk about, and you'd be expected to give quite a lot of application in order to get to cover that. So rather than you can't just say, oh, here's the 3 elements from GIF Lemon. You'd need to apply those and go back and find the additional information in the question paper, and also the facts from the advance, extract those and apply those in your answer there. Next question here, 2B. Could a trademark be registered for Serenity and or the slogan Serenity on Wheels? So this is moving on then to talk about registered trademarks. We've looked quite a bit at questions like this. If you don't remember, have a look back at it's Unit 6, the first exercise we did on this. You'd be looking here whether there's any difficulty under Section 3 or Section 5 in relation to registration. You also, of course, would need to make sure you're not passing off yourself, that there's not somebody else that's got the mark. Seems unlikely here, bearing in mind they've been selling on this basis under this name for all this time without any difficulty. So that seems unlikely. And it talks about in the facts their name is associated with the trademark Serenity, the currently unregistered mark Serenity, and also Serenity on Wheels. But you'd need to check, wouldn't you, to make sure. So passing off would be one thing to think about, unlikely on the facts. The more salient points would be likely to be, is there an existing similar mark under Section 5? Nothing on the facts to suggest that, but just to mention. And then also then to think about here, Section 3, absolute grounds. That might be problematic here, I would think, in relation to, Serenity on its own, probably all right if it's not been registered by someone else or used by someone else. Your possible problem would be with the slogan, in particular on wheels, because it's something for cars that might be seen as descriptive. Maybe, we'd be trying here, you'd be mentioning cases like double mint, and, maybe if you can argue it's more like baby dry than double mint, then, maybe it might get protection. And also, of course, you might be able here to argue, as they've been using it for time, that although initially it might have had a problem as they've been using it for 6 years, that it's acquired distinctiveness through use. So that might be something to mention here. So that would be something to mention in the answer. Okay, so that's 1A and 1B. So distinctiveness through use might have arisen here to override any problem under Section 3. You'd need to check if there's a problem under Section 5 or a passing off problem. As I say, as they've been using it for 6 years, you would think that probably not, but you would need to check that, obviously. The more obvious question mark is around the descriptiveness here under Section 3. All right, question 2C then, advantages of registering a trademark. A number of advantages, things like it makes an infringement action like the one against Axel here more straightforward and easier, right, so on the assumption that no trademark has been registered, sorry, where did we get to? Yeah, we're talking about the advantages of registering a trademark. So the advantages of registering a trademark. The advantages would be, as I've said, infringement action, like with Axel, is easier. No need to, it's more straightforward than passing off. You don't have to show goodwill, for example. You've got, once you've registered. Once you've registered, the second positive is that it's a very long, it's unlimited period of protection, so long as you keep renewing and keep using the mark. You don't need to show the any goodwill to register. Another advantage, it's on the public record, so people know it's your mark. And another advantage is you can license your mark. You can exploit it once you've registered it. So that would be another advantage. So quite a few advantages. And I would say for 5 marks, you'd just be looking at a sentence for each, really. Okay, moving on to question 3. In relation to the protection of the new aerial system, what are the potential rights in the new system, the drawings and the prototype? 6 marks, there's not a lot of marks there, so you're not looking at a lot of content in terms of a lot of detail. Patent might be a possibility for in relation to potential rights here, but notice you're being asked more about that at B, so just say the word patent, certainly no more. So patent if new invention, I wouldn't say any more than that. Copyright potentially for the drawings as an artistic work. I'd expect you to refer to the section number there. Could also be copyright in relation to any instructions or whatever, but it's specifically asking about the drawings here, so you'd be talking then obviously about copyright in those drawings. And then also then you'd be talking here about design right potentially. There could be design right in aspects of the new system and also in the prototype, of course, and that could be both registered design right and unregistered design right. And I'd expect you just here to give a little bit of detail about what the difference is, so just explaining what would be protected, and the fact that the sort of key exclusions here for registered design right, if it's for technical function, it's excluded, and also the interface exclusion. And if it's part of a complex product, then again, that the anything that's not on view during normal use is excluded. And likewise for unregistered design right, the requirement is that it's original and not commonplace in the design field, and then just to talk about the fact that it protects shape and configuration, and again that there's must fit and must match exclusions that would need to be would not be able to be protected. So you could talk a bit, but remember only 6 marks, so not a huge amount to say there. B is asking about patents. Could it be obtained and what would they have to establish? That's basically here you'd need to talk about the 4 elements, obviously. Novelty, inventive step, industrial application are not excluded. Here the key thing is, is about the state of the art for novelty, and whether this would be obvious in terms of an inventive step. Is it the obvious next step to an uninventive technician and knowing everything about aerials but with an inventive blind spot? A key issue I would expect you to pick up here on the facts is the road trials. It talks specifically, if you look back in the facts here, just above, it talks about the fact that the team has produced a number of drawings and a prototype which is tested well in road trials. The risk with that, of course, is that could be considered, it may well be that that's an enabling disclosure, which may have destroyed the novelty. So I'd expect you to say a bit about that. Of course, it depends upon whether someone can reverse engineer the product from what they've seen in the road trial. But bearing in mind these days, even sort of basic phones have cameras and can record things, it's quite likely that it would be an enabling disclosure. All right, so that is B. Moving on to C. How can it best protect the information from getting out prior to applying for a patent if one of the research staff does join a competitor? We talked quite a lot about this last week, so this should be very fresh in your mind. This is about the duty of confidence. And making sure that everyone is under an obligation of confidence. The research team, we're told, is 4 people who are all employees, all right? Talks about that in the facts here. The research team consists of 4 employees. So one of the things to mention here is that They're all employees, so you could have dealt with this in the employment contract. Check the employment contracts. If it's not in there, then you would want a freestanding confidentiality agreement. It would be best also to deal with this in the employment contract and to also have a restrictive covenant preventing them going to work for a competitor for a reasonable time. Remember that it has to be a reasonable in time and scope in order to be effective. Otherwise it will be considered an unreasonable restraint of trade. So it would be good to have a confidentiality provision and also to have something in there in terms of a restrictive covenant. It would also be a good idea, if they haven't done so already, to indicate to these staff members that this is a trade secret. Of course, even if there isn't something in writing, so if there's not anything in the employment agreement, you could have a freestanding confidentiality agreement with them. In the absence of that, of course, there is an implied duty, even after employment, to protect trade secrets, but it would be far better, of course, to deal with this more clearly and explicitly. You would also want to try and limit who has access to the secret information. That would be important. And to make sure, of course, there may be other people who are not working on it directly who hear of this. So make sure all staff who have information about the product, and all, even if they're independent contractors, anyone who gets the information should be subject to a duty of confidence. All right, so D here then. What advice would you give Brad Gilbert concerning his rights in the new aerial system? That's the next question. The thing to note there is that's a question that's asking you, obviously, to advise Brad. Our difficulty with that, of course, here on the facts is that we act for the company. So therefore, this is a question about conduct, professional conduct. Brad is an employee of our client. We're acting for the company. Therefore, there is a conflict of interest. So you would be expected, in answering this question, to deal with that conflict of interest point, to flag up where the code of conduct deals with conflict of interest, which is obviously 6.2 in particular. He would need to be independently advised. It's clear here the exceptions in 6, such as substantially common interest, do not apply. All right, so it's quite clear that it would not apply, and so therefore he would need to be independently advised. You would, of course, likely have a problem with confidential information here as well, that you'd already have confidential information, and that's dealt with obviously in 6.3 to 6.5 of the code as well. So you should not be advising Brad on his rights in the new aerial system. Just to point out that in any of your electives, you could get a question around conduct. So question 4 then is the final big question. Assuming that they have decided to proceed to appoint Pierre as a distributor, and we've got the agreed terms, competition or difficulties. We've got to explain the competition or difficulties and how you would suggest resolving them. And for the avoidance of doubt, you're not required to draft any clauses. To be fair, that would be true for any of the questions. This is not a drafting exam, so you're not going to be asked to draft clauses. Like here, it talks about how you would suggest resolving. That just means, well, you'll see when I talk through it, but just, what would be, you'd be suggesting take this out and change to say the following, to cover as, something along these lines, but not drafting, not wording, just, what's allowed and what isn't, basically, as you'll see when I go through it. So first of all, we need to explain the competition or difficulties, and then we need to suggest how we would resolve it. Okay. Now, competition law then, this question, just to be aware then that this is asking, as we said about competition law, you're told not to draft the clauses. First of all, we need to deal with problems. Secondly, how do we resolve them? This is a distribution agreement, and some of the clauses, so looking at the document, summary of agreed terms for inclusion in distribution agreement. So it's going to be a distribution agreement. As such, potentially subject to competition law, whether it's domestic under national competition law in the UK, or whether it is subject to European provisions under Article 101. This agreement, as it stands, I would expect the territory is France, so you expect it to be having obviously a European aspect, so it would be EU law you'd be considering, and therefore whether it's potentially anti-competitive and problematic under Article 101. Now, the key thing to note here when you start answering this question is that you've got very little information about the companies in question. So we're simply told that they've decided they want to extend into Europe and that they're going to appoint a distributor. The key thing that you don't have anywhere here is any information about market share. So that means, therefore, that you would need to talk about all the different possibilities in your answer. So you'd need to say, first of all, that this is a competition law issue, and that you need, therefore, to look at the different areas, a number of different areas that you want to think about. So potentially, depending on market share, it could be a very small agreement. So if the market share is under 15% each, you're looking at notice on agreements of minor importance, the de minimis, as it's sometimes called. If it's under 30% each, it's the vertical restraints block exemption potentially. But then in addition to that, just going to pause for a second. Let me just... Right, I'm getting a lot of kind of fairly distracting messages. Okay, so my apologies for the pause there. I just found that I was getting a lot of quite confusing messages that were coming through, so I've just disabled those. So to continue then, just going to move you. I'm going to move back to the question paper here. So we're saying here that the competition law difficulties, so explaining those, and I was making the point before I paused, that because it doesn't tell you the market shares, you'd need to talk about the different possibilities. So if it's a very small agreement, under 15% market share each, that's the notice on agreements of minor importance. If it's under 30% each, that's the vertical restraints block exemption. If it's over 30% each, then you'll be looking at an individual exemption, seeking that under Article 101(3). You'd only do that if you were too big in terms of market share to bring yourself within the block exemption. In all of those cases, the same types of clause would cause problems in terms of things that are prohibited. So you can't have anything that is price fixing, or that is an export ban. Those types of clause would be problematic, whichever category you came into. So here we're not sure, as we said, what the market share is, but we would hope, obviously, that the vertical restraints block exemption would apply at the very least. So that's what we'd be looking for. All right, but just be aware if the question doesn't tell you what the market share is, you do need to talk about the different possibilities. So then let's move on then to talk about what the clauses actually say. So looking at these clauses, the first one is appointing them exclusively. That obviously indicates there's an element of exclusivity, and from an Article 101 perspective, it might be interesting. Then we're moving on then to look at the term here. It's initial 3 years, but then continues indefinitely. Clause 3 goes on then to say that the distributor cannot sell outside the territory, and that covers both solicited and unsolicited. So it's a total ban. That's a complete export ban, which is along the lines that I was just talking about. That would be not permissible in any type of agreement under Article 101. And if it was the vertical restraints block exemption, then under Article 4B, that would be a hardcore provision. And that you need to be aware of that first of all. So that would be a hardcore provision potentially. Then the next clause you've got distributor will be required to follow guidance on prices. Again, that is problematic. Remember, I said price fixing is another thing that's not allowed. So this would be problematic. And again, under the block exemption, that would be hardcore under Article 4A. So that would be a problem. Clause 5 here, the distributor will not, for the duration of the agreement, manufacture or sell competing products, basically. It's a non-compete clause, and you'll see that when that goes together with clause 2, if it is under the vertical restraints block exemption, that would be a non-compete clause that is exceeding 5 years, and therefore that would be a problem under Article 5 of the block exemption. So you've got potential problems here with a number of the clauses. Right, so what could you do? Well, in relation to solving the problems, well, I guess the point is that if you don't solve it in relation to the clauses that are void, it doesn't just make the clause void in relation to if it includes hardcore provisions like the restriction on territory and the pricing. Those would make the whole agreement void, potentially, and there's the potential for fines up to 10% of worldwide turnover. Also, potential action by competitors or by your own distributors. So that is problematic if it's left as it is. And the non-compete provision, if it's not changed, then potentially your issue there is that that clause would not benefit from the block exemption. It would fall outside it. The rest of the agreement could benefit from the block exemption, provided that that clause 5 is considered to be severable. If it's not severable, then the risk is, if you include a non-compete clause that's too long, that the whole agreement could be void. And the case we talked about in relation to that in Unit 5 was McCabe and Scottish Courage. That's in the note for Unit 5. All right, so we're saying that the non-compete provision, it's not hardcore under Article 4. So under the block exemption, it wouldn't render the whole agreement void, but it would, the clause itself would not take the benefit of the block exemption. And if it's not severable, it could put the whole agreement at risk. So in terms of what you could do, because we've looked at what the problems are, so let's look back at the question. We talked about the competition law difficulties. How would you suggest resolving them? Your suggestions could be that Clause 3, the territorial restriction, should be narrowed so that it is only goes as far as is permitted by the block exemption, all right? And what you're allowed to have is, in terms of restriction on selling, you can only restrict from active selling into territories that are reserved either to the manufacturer or to another distributor. So you'd need to narrow that down. And as I've said, you don't have to draft it, but just explain like I just have. Right. So this is too extensive at the moment and would render the agreement void. To bring it under the vertical restraints block exemption within permitted limits, you would need to narrow it down. The only restriction that's allowed is passive selling into restricted territory. So you would need to. No restrictions allowed on passive selling at all. The only restriction that's allowed is on active selling, so going, looking for customers in territories that you've reserved either to the manufacturer or someone else. So all you're allowed is to restrict active selling into territories that are reserved either to the manufacturer or to another distributor. If you go further than that, then it will render the whole agreement void, potentially. You can have no restriction on passive selling, that's unsolicited sales that it refers to here. So those can't be restricted at all. The only restriction you can have on solicited or active selling is in territories that are reserved to the manufacturer or another distributor. You can't restrict active selling beyond that, and you can't restrict passive sales at all. So that's what you'd need to do in relation to 3. In relation to 4, you can't price fix, of course. You can have a recommended price or a minimum price, but you'd have to amend clause 4 to fit with those aspects of Article 4A. And then in relation to the non-compete clause, it would be safest to amend that so that the restriction is for less than 5 years. Right, so I'd leave the term alone. The agreement can last for longer, but limit the restriction in clause 5 so that it doesn't exceed what's permitted by the block exemption. So you can see there that I've answered that question. I've explained the difficulties and also how you could resolve them, and I haven't drafted anything. So that's question 4 answered. So I've been through all of those questions, and remember, you may have more questions than 4, but it will only ever add up to 85 marks. All right, so moving on then to the final part, it's the MCQs. All right, so let's have a quick look at these, and what I'll do is I'll run through what are the correct answers, and then I'll also talk about why they're the correct answers. All right, so let me just get my answers in front of me, make sure I give you the right answers. Okay, so looking at the first one then, let's just move it up the page a bit. Remember, each of these is worth 3 marks, so it is worth spending a little time to try and pick up as many of the 15 marks as you can. So the first question here is about Incoterms, and it talks about which of these is correct about FOB. And the answer here is D, none of the above are correct. Okay, so none of the above are correct. The reason for that is that risk passes when the goods are on board under FOB, and that's dealt with on page 185. If you want to remind yourself what Incoterm FOB is about, page 185 deals with that. But D is what you'd need to tick here, because none of these are right. It doesn't pass at the seller's premises. It doesn't pass at the buyer's premises. That's not where delivery takes place. It's not at the dockside. It's when the goods are loaded on the ship. So none of those is correct. Number 2, this time we're looking for the wrong answer. Okay, so an object, so we've got 4 possible answers here, A, B, C, and D. The correct answer here, when I say the correct answer, the wrong answer, the one you're looking for, is 2A. An object cannot be registered for design right if it's been disclosed prior to registration. Yes, it can. That's the grace period of 12 months that we've talked about quite a bit. So yes, it can be disclosed prior to registration. So A is wrong. The others are all correct. It has to be new and have individual character. So B is correct. If the design is created during the course of employment, it belongs to the employer. That's correct as well. Remember, we looked at that in class. And then also, yes, section 26 and 26A is referred to here, deal with cases of unjustified threats. So that's also correct. So 2A is the wrong answer. Number 3 then is about appointing Andrea Poch in Germany. And the answer you're looking for here and is the correct answer this time. And the correct answer here is D. None of those are correct. Students sometimes get this one wrong in the mock. The reason for that is the key words here are they're appointing Andrea Poch as its agent in Germany. It's appointing her as its agent in Germany. And therefore, that agreement should not normally, as you'll remember from the session on agency agreements don't normally fall to be considered under Article 101. So A, B, and C are all incorrect. So just be important. That question, I think, really demonstrates the importance of reading the question carefully, because a lot of people look at those answers and think about distribution, but this is agency. So if it's a genuine agency arrangement, then D, none of the above answers are correct, and that should be the one that you should have identified there. Moving on to question 4, this is talking about letters of credit. Talks about which of these is correct. This one, C, is correct. Letter of credit may be confirmed by another bank. That would make it a confirmed letter of credit, or confirmed documentary credit, as it's sometimes referred to. But it doesn't have to be. May is important here. It talks here about the fact it won't be honoured if there's a problem with the quality. That's not true. Remember, we talked in SGS 3 about the fact that the documentation between the banks is a completely separate contract, so that the problem with quality is irrelevant. It doesn't have to be irrevocable. It may be. Okay, you can have revocable documentary credits as well. So B is not true. And so C is true. Therefore, D is incorrect. So looking here then at C as the correct answer. And then finally, question 5, which of the following statements about copyright is incorrect? Again, we're looking for the wrong answer. The wrong answer here is B. It says the initial owner of a copyright work will always be the author. As you know, that's not correct. It may be, of course, if it's in the course of employment, it could be the employer. So the others are correct. Made-up word wouldn't normally satisfy the requirement of substantiality. We talked about that and the fact that trademark would be better. Under C, literary, dramatic, musical, or artistic work must be original. That's true. We know that has to be certify originality, quite a low threshold, but it's still a requirement. And then here, importing infringing copies will not be primary infringement. That's correct. It would be secondary infringement, of course, secondary, not primary. So that means that B then is the wrong answer because of employment situations where the employer could be initial owner. So I've gone through in quite a lot of detail the mock, and that feedback's available to you to listen to and to think about. And I'm going to, in the sessions, I'll discuss with you any queries you may have in terms of the feedback, anything that's not clear, anything you want to ask further, so long as, of course, as you raise your questions before the advanced facts. So what I'm going to do now is to finish the recording, and you can ask me questions in the sessions on Tuesday evening or Thursday morning. You can also email me if you want to, or put your questions on the commercial discussion board if you prefer. So I'm going to finish the recording now, and I will, as I say, talk to you in class if you've got any particular queries.